Hi there. In this presentation, I want to comment on ending the lawyer-client relationship. It's a topic keyed to the casebook, pages 77 through 86. There's a theme running through this material, and it's this. If you leave enough time to mitigate any harm, you can usually, not always, but you can usually find a proper basis for withdrawal. There are a lot of tools available to lawyers here to eventually get out of a lawyer-client relationship. On the other hand, if you need to turn this around in a hurry, that's going to be much tougher, and there will be some situations where you're stuck and you just have to carry through and do your very best for the client, even though withdrawal might be justified under slightly different circumstances. Particularly when you're dealing with litigation matters, you got to convince the judge and you got to live with the judge's decision about this. Rule 1.16 sets out the ground rules for termination of this relationship, and notice that it divides the world into two parts. There are the mandatory withdrawals of 1.16a, and then there are the discretionary withdrawals of 1.16b. So whenever you're facing one of these withdrawal questions, you're always looking for the may-must language. Is the question, may the lawyer withdraw, or is the question, must the lawyer withdraw? And that tells you which chunk of the rule is going to be in play. As for these mandatory withdrawals under 1.16a, you've got to withdraw if, first of all, you're going to have to violate the rules of professional conduct to continue. An example might be you take on a client, you get into it, and you realize, uh-oh, I can't provide competent counsel here. I have an obligation under Rule 1.1 to provide competent legal advice. I can't do that going forward. I've got to get out. So violating the rules it means that you can't go forward. You have to get out. I have a heart attack or some other, material impairment of my physical or mental condition. At that point, I have to, withdraw from representing my clients, doing whatever I can to mitigate the harm, as we'll talk about later. But major, physical and mental impairments could be the basis for an obligation to withdraw. And then finally, if you get fired, you can't keep on representing the client. The client fires you, you have to get off the case, even if you think the client made a stupid decision and think the client may change his or her mind later. If it's clear that you have been discharged, then you have to withdraw. Take a look now at the discretionary withdrawal grounds under Rule 1.16b. First thing I want you to notice, there are a lot of words on this screen. That means it's a long list. You've got a lot of options to find the proper grounds or a proper ground for as justification for withdrawal from a relationship. So there's no shortage of options here. The first is among the most important, so if you can show that there's just no material adverse effect on the client, the client's not hurt by this. I can do this in a way that doesn't hurt the client in a material way, then you're justified. Of course, if you can get client consent, that is very good. That's at least some evidence. It's not conclusive evidence, but it's some evidence that there's no material adverse effect on the interest of the client. Take a look also at numbers 6 and 7. These are two of the more spacious grounds for withdrawal. Notice other good cause, the catch-all provision. But then there's also the unreasonable financial burden provision, a very often invoked ground by lawyers, or the whole representation has been rendered unreasonably difficult by the client. Obviously, a lot of room for interpretation there, and bar authorities tend to give attorneys some wide latitude in interpreting that language. So lots of tools available to the attorney. Now, these justifications in Rule 1.16 indicate that some effort is required to justify. The lawyer can't withdraw just for any reason or no reason. It's got to be one of the acceptable reasons, and the lawyer is not alone in making this judgment. You have to convince somebody else. In the litigation context, if you've already filed a case and you've got a judge, assigned to your case, it is all in the hands of the trial judge. And once you have made your motion to the trial judge and the judge has spoken, the judge might be right or the judge might be wrong, but it doesn't matter. You've got to do what the judge says. If the judge says stay on the case, you've got to stay on the case and give it your best efforts, even though that may be challenging sometimes. As for the non-litigation matters, again, eventually the attorney's judgment might later on be questioned. It might happen in some kind of bar disciplinary proceeding. That's not very likely, doesn't happen that often, but a possibility. Or slightly more realistic would be a civil suit, some kind of malpractice suit, possibly a breach of contract, something along those lines. So it is possible for the lawyer's judgment to be second guessed by other parties, but the most important here is the trial judge in litigation matters. All right, so 1.16d contains the heart of the rule. This is the do no harm principle. Now remember, under 1.16b, the discretionary withdrawal, one ground for doing that is you can show from the outset that the client won't be hurt at all, no material adverse effect. But there are other grounds where you can withdraw even though there is a material adverse effect. When that happens, you have to do everything you can to minimize that adverse effect. Typically what that means is time. It's hard to do this quickly, hard to turn on your heel and be out the door the next day. It takes time to transition the client to some other lawyer, to transfer their files, particularly in a litigation setting. This is why judges' first question is always going to be, when's the trial? When is the trial set? If it's tomorrow, you're not getting off this case. If it's several months from now, there's time to transition to the next lawyer, get them prepared. The court's calendar won't be hurt. The client won't be hurt. More possible. So the key idea here is time. You see the particulars here, and I won't reread those. So this is in question 1. We've got Alpha, who suffered a heart attack and couldn't return to work for 6 months. Notice exactly what the question is. The question is not, must Alpha withdraw? If that were the question, the answer would be an easy yes. This is one of the classic grounds for mandatory withdrawal under 1.16a. The question here instead is, after this withdrawal, was it proper for Alpha to deliver the files to Beta for review? And here, I think our best answer is here, D, no, because under Rule 1.6, there are special rules for sharing the confidences of clients. Boy, it's tough to write numbers with this thing. Rule 1.6, the confidentiality rule, is briefly quoted on page 79 of your casebook. We haven't really gone into that yet. That's a major unit for later in the course. But the point here is that while the withdrawal was appropriate, even mandatory, you've got to leave to the client the choice of who the next attorney is going to be, if anyone, and you can't pick that attorney for the client and then hope that the client ratifies that later. You can recommend, in fact it's a good thing, a positive good thing to recommend another attorney, but you can't transfer those files until you've gotten the okay on confidentiality grounds. Okay, question 2. Notice how the question is phrased. Must the attorney withdraw as counsel? So we're looking at 1.16a mandatory withdrawal grounds. question is whether continued representation of this client would involve a violation of the ethics rules. Your book gives you a pretty major clue here that Rule 3.1 is relevant. It prohibits frivolous claims, but as long as you can, this is a very loose requirement, as we'll see later in the semester. As long as you can make an argument take a position that's supported by a good faith argument, then you're not violating the ethics rules by going forward with that position. So, in this case, as long as you come up with some plausible legal argument here, then the general counsel's position, never settle, never, ever, ever settle, can be justified here, and the attorney does not have to withdraw under 1.16a. All right, for question 3, this one's really pretty straightforward. This is just the classic judge is in control. So C is our answer here. Even though it's going to be difficult, you may not be able to do as good a job as you would like. You have to do the best you can because you tried to get off the case. The judge said no. You have to go forward and do your best. So, can Melanie withdraw? Probably yes. This client is not fulfilling a financial obligation that was part of the original agreement. But remember, we're dealing with a judge here. This is litigation. So if the judge does not sign off on the withdrawal, then Melanie can't withdraw. Let's back up for a minute and ask about other possibilities. Is there any strategy available to Melanie other than withdrawal? For instance, could she just say to Bill, well, we're going to have to approach this case differently now, and we're going to have to live with a tighter budget for discovery purposes. We're going to have to cheap out on the discovery. You can't pay for the investigator that this case really needs. Is that acceptable? The quick answer to this preliminary question is yes, the lawyer and the client can agree to some kind of less than full funding for discovery. The lawyer can never agree to give less than full effort on his or her part, but the client and the lawyer can explicitly agree, probably this should be done in writing and certainly ahead of time. But the client and the lawyer can agree that certain ancillary services like investigators, just staffing the case generally might be funded at a lower level than might be optimal. The lawyer can never agree to say, I'll go at 50% effort for you here. I'm, not going to really pay close attention and won't give you my best work, but you'll only pay half my rate. That's not acceptable under the rules. We always have this ideal that the lawyer himself or herself is always going full bore, but you can create a discovery budget, number of hours, number of ancillary services, and so forth. So that would be a possible strategy here. But what about withdrawal? If instead the strategy were withdrawal, how would Melanie do it? We've already said that she can, very likely if the judge agrees, but how would that happen? So how would Melanie go about doing this? Well, the first step, of course, is consulting with Bill, reaching some kind of understanding with Bill. Bill doesn't necessarily have to consent, but Bill certainly has to understand what Melanie proposes to do if you're going to avoid any kind of claim of incompetent lawyering later on. After the conversation with Bill, then the next step would likely be to file a motion. This is tricky. You need to file the motion explaining things in a way that does not harm the client. So You would not be filing a motion that just said in a forthright way, well, Bill's kind of broke and he can't really afford to pursue this anymore. The other side's just about to run him off the case anyway, so I need to get out. That really is a flag both to the judge and to the other party that will likely see the motion, unless you can get a motion to seal it, that Bill is on the ropes and is about to lose. So you can't frame it in a way that will prejudice the client. You can use more subtle language to invoke some of the more general grounds that the rules allow, and if the judge asks for some explanation, you might ask for an in-camera hearing and give more detail there with the other party not listening. Again, you still have to be careful. You don't want to leave the judge with the impression that this party has no case and really should lose the cause of action. After you've filed the motion, putting some effort into finding the next attorney will be very helpful, might even be necessary. If you can't find a new lawyer, Bill might end up representing himself pro se. That probably is not going to be something that the court will agree to. So finding that next attorney, if not making the call yourself, at least giving concrete suggestions. Attorney A, attorney B, you might even call ahead of time and smooth the path if you can. But some kind of help with the next attorney is what you would do as the first attorney with a fiduciary obligation to your current client. And obviously, once you have stepped off of the case, you promptly give the files to Bill. The client owns the files, including the work product, at least most of the time, and the files should be turned over swiftly. This is one of the great provokers of malpractice claims. Clients hate this, and rightly so. So a fast turnover. If you want to keep a copy of the file for yourself, which you probably should, you need to copy it at your own expense, not at the client's expense, unless there's some kind of provision in the fee agreement to the contrary. Okay, so that covers this topic of withdrawal.